The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Good evening. We welcome the students from DMAC Business Law class this evening, as we do everyone who has gathered with us for this evening session of court. We have one case that will be heard. That case is State of Iowa versus Eddie Raymond Tipton. Mr. Stowers, you may proceed.
May it please the court, I'm Dean Stowers. I represent Mr. Tipton in connection with this appeal and these further review proceedings before the court. First thing I'd like to do is just point out to the court that obviously there's been a lot of briefing that we've done in this case, both in the further review application and in our petition for rehearing before the Court of Appeals, as well as our reply brief and the appellant's brief that we filed, and I don't want to forget any of those things or have the court not have the opportunity to review those as it considers this appeal. So I just draw those court's attention to those four filings. But this case, Your Honors, concerns a further review of Mr. Tipton's two convictions in Polk County relating to activities alleged to violate Iowa Code Chapter 99G, Section 36. There were two counts filed. The first count was that ultimately, as it wound up going to the jury, was that he personally, on his own, as the principal, either redeemed or attempted to redeem, in this case they went with the attempt to redeem a lottery ticket, or he passed a lottery ticket with the intent to defraud. And that's the first charge. And the second charge is, as it was ultimately submitted to the jury, although it was earlier filed in broader and different forms with other alternatives, it was that he was charged with tampering with lottery equipment with the intent to influence the winning of the lottery prize. And that count, as it wound up being narrowed down at trial, was defined on a particular date, which was November 20th of 2010, that the state ultimately alleged that occurred, and that's the basis upon which the jury was instructed. The case kind of went like this. The state offered as an exhibit a videotape that one of the DCI agents had retrieved from a Quick Trip store on Northeast 14th Street here in Des Moines. There was no foundation for the exhibit other than he had retrieved it from there, and he believed it to be the video of the actual purchaser purchasing lottery tickets on December the 22nd, 2010.
Does the record indicate when the videotape was retrieved?
There's a couple of different dates described in there. One is January of 2011, after the drawing, and then there's discussion in the record as well of some later recopies or other versions of the same thing that were retrieved later. But in any event, they retrieved this videotape, which they took the position that's the videotape. There were foundation objections made to that videotape, overruled by the trial court. Those particular evidentiary issues aren't pertinent here, but I just want the court to know that the only evidentiary record on what that videotape is whatever it was at the time of trial, and it is that that's the videotape they retrieved from the Quick Trip.
Well, and there were 8 witnesses that said it was your client on the videotape.
Well, I would say that the witnesses actually said different things at different times.
They did, but some of what they said was kind of strong. Beyond any doubt whatsoever, that's Cubit. Why am I listening to a tape of Eddie? That's Kruger when the tape is played. That's Eddie. Literally makes me sick to my stomach. Now, you did cross-examination, and you did what lawyers do, and attacked them. Yet, on appeal now, our question is whether there's substantial evidence to support a determination.
Right.
And I invite you to convince me that there's not substantial evidence that your client is a person that's on the videotape.
Well, there's evidence from witnesses that the person that they believe whose voice they heard on the videotape is Eddie Tipton. There's no question. There's actually affirmative testimony to that effect. And on the sufficiency of the evidence challenge on the question of whether or not some people believe that's his voice, yeah, we lose on that. But that's not the crux of the appeal. The only point I would make is when you actually look at what some of these witnesses said, there's 9 words spoken by the person who's the customer on this video.
Let me tell you why I think it might be a crux of the appeal on at least one issue, and that is the substantial evidence
Right.
question. And if the identification hadn't been made, you may well have a point. But here, I mean, the coincidences just add up beyond belief. Eddie Tipton, who is a security expert, goes into the Quick Trip right across the street and just happens to buy 2 tickets, and by golly, he wins $16.5 million. And away we go. And it seems to me, on your substantial evidence argument, the key thing is the identification. I mean, what are the odds of someone walking into a Quick Trip and hitting 16.5 in the hot lotto?
Well, there's no evidence in the record of what the odds might be. So that would be one thing I would say. The second thing is you made a statement about what the evidence is about how many tickets were purchased, and I believe the evidence shows there was actually 3 tickets purchased. The drawing was held on December the 29th of 2010, and there's no indication that the person who purchased the tickets would have known that the winning number would be drawn on the 29th of December 2010 when they purchased the tickets. And there's no evidence that they would have had any way of actually knowing what the winning number might be, any more than anybody else who might play the lottery and might win would be. And the fact is, there was an instruction given in this case that purchasing the lottery tickets isn't in of itself isn't a crime. There's no offense committed by buying lottery tickets if you work for the Multi-State Lottery Association, etc. Now, what the real issue is, there's 2 specific offenses that they charged. One is that he attempted to redeem those lottery tickets, of which there's absolutely no evidence that he did anything to attempt to redeem those lottery tickets.
Unless you believe he bought the tickets.
Well, no, there's no evidence that he actually attempted to cash those in. There were some other people who were never
Well, there's no
connected.
direct evidence. There's no direct evidence, but let me just spin part of it, and I invite you, of course, to push back, because I know he will, but if the jury believed that Mr. Tipton bought the winning ticket, if the jury believed that he was the guy in the videotape and that was when the winning ticket was sold, and then it turns up in Johnson's hands and then in the lawyers in New York, and it turns up on the last day in the doorstep, that Tipton must have had something to do with it.
Well, I would suggest that what you're talking about is things that occurred a year apart. And the ticket, basically, according to the state's own concession, the ticket was apparently last seen when it was issued at the convenience store, and then it surfaced a little over a year later on December 29th, 2011, when the Davis Brown law firm cashed it on behalf of Mr. Shaw from New York and this Hexham Investments Trust, etc. So we have this big 1-year gap. And we have no nexus, no connection at all between Tipton and Shaw, Tipton and Johnston, Tipton and anybody else connected to that claim, the Davis Brown law firm, etc. The ticket simply shows up in their hands and they're claiming it. Now, we don't know why they were claiming it.
Does Tipton have to be the person that steps forward for the redemption to occur?
Well, the charge on the attempted to redeem was that he was the one that attempted to redeem it because they had originally alleged that he aided and abetted others. What happened during the trial was they didn't have any evidence of that. So the trial court dismissed that claim with prejudice, the aiding and abetting others claim, and left him solely with the liability as a principal. And that went out the window because, in our view, there's no evidence he attempted to redeem the ticket whatsoever or had anything to do with it being claimed.
Can I turn your attention to the statute before we
Yes.
run out of time here? The Court of Appeals threw Charge A out because of the statute of limitations, as I understand it. And on Charge B, which is the influencer attempts, I guess there's two issues in my mind. Number one, was it a fraud type case? And number two, how did the discovery rule work? What's your position on whether or not the civil discovery rule, outside of medical negligence, because that's a special one, but the discovery rule, the civil discovery rule applies, or is there a special criminal discovery rule?
Well, it's the Wilson case, State versus Wilson, is the case that sets out the discovery rule. And in State versus Wilson, the Iowa Supreme Court held that the discovery rule apply if the state is seeking to take advantage of 802.5. And they explain in that case that if you wish to take advantage of the extension provided by 802.5, if it's an offense that's subject to 802.5, which we believe the tampering count is not because it doesn't have a material element of fraud as one of the proof elements. So it doesn't even come into play for count 2, the tampering charge, because that's not an element of fraud.
Well, the discovery rule in the civil case says doesn't begin to run until the plaintiff knows, or through exercise of reasonable care, should have known both the fact of the injury and its cause. So if you take it to a criminal case, first the facts of a crime and its cause.
Well, right, but the way they explained it in Wilson is a little bit different than that, and I'm just going with what the court said in Wilson. And what the court said in Wilson is, if you're on notice that something's wrong, in this case, they were on notice that something was wrong as these events were transpiring at the end of 2011, early 2012.
Well, but that's not, I'm sorry, but that's not quite what Wilson says, and I'm just reading it. They're citing State v. Bumpus, another case, but they say that discovery is triggered when a reasonable and prudent person would believe that the crime has been committed and that the person arrested committed the crime. Now, is there a requirement that you have some knowledge that a particular person committed the crime, or is it a more general notion that you now know that a crime of some type has been committed?
There's two parts of this Wilson case. There's the probable cause prong. Obviously, if they have actual probable cause to charge, then that's the discovery date. And I think that's what you're referencing.
Oh, they didn't know that. I mean, frankly, I think they knew that something was amiss rather early on, and that's one of your points, and I think that's pretty good. Someone presents a ticket, but obviously wasn't the one who, I'm talking about Johnson, right? Johnson presents a ticket and turns out that he wasn't the guy at the video, and then we had this Belizean trust, and then we have withdrawal of claim, and and all this happens in 2011, and so it seems to me a fair case can be made that they were on notice that something was wrong, but they weren't on notice of a potential tampering until much later, and they weren't on notice that your client was involved until 2014, or potentially involved, 2014 when they released the videotape of the Quick Trip and so forth.
Right, but in Wilson, I'm just looking at Head Note 9, at the end of that, they quote the Sparks versus Metalcraft test. And in Sparks versus Metalcraft, they say that the knowledge of the injured party, in this case, whoever the crime was committed against, or the state of Iowa who's charged with investigating, is attributed to them on the date of the accident or the event with knowledge of what a reasonable investigation would have disclosed.
That's the point. If you apply the civil discovery rule, once the state is put on knowledge that a crime is being committed, and I think they knew that because they went and cashed a ticket or something was amiss, they have a duty to use reasonable care or ordinary care to discover the crime and the perpetrator.
Right.
And They had this quick trip tape early on, but they didn't put it out for 3 years or 4 years. I can't remember the exact date. But my concern is, even if we use this civil reasonable person test, don't you at best get if discovery rule applies, of course, isn't it best you just get a jury instruction as to what was reasonable by the state in discovery? Because in civil cases, you usually get a jury instruction whether or not they were reasonable in what they did to look for the crime. You don't get a at-law thing.
Well, it depends, right? I suppose it would depend. If they, see, the burden is on the state in a statute of limitations case to put on evidence and prove up the exception that they're relying on. In this case, we say there's no exception. First of all, because the statute would have, see, I'm running out of time here. The statute would have commenced to run when they were on this inquiry notice, okay? So under 802.5, if you do an 802.5 analysis on inquiry notice, it's happening as the events are occurring in late 2011, early 12. So then you start the 1-year clock ticking at that point, and that brings you to the end of 2012 or early 2013. But they've already got a 3-year statute for general felony offenses. For any fraud case, you get a 3-year statute. The problem is they would have to have proven that they could not, in the exercise of reasonable diligence, discover this offense for a period of time more than a year before they filed the trial information.
And the perpetrator or just the offense?
The offense and the perpetrator before January 12 of 2015. So they would have had to prove that they couldn't have reasonably discovered it then. And they got the videotape. And once they played the videotape, that ended it. I see I've consumed a little extra time answering your question, and I'll be back for rebuttal. Thank you.
Thank you as well, Mr. Stowers. Mr. Sloven, you may present your argument on behalf of the state.
Thank you, Mr. Chief Justice, and may it please the court, counsel, members of the public. Good evening. My name is Louis Sloven. I represent the state. I want to start by elaborating on the set of facts that you laid out, Justice Apple. Eddie Tipton walks into this quick trip and buys these tickets. Then the ticket disappears and he never comes forward with any information about it. Then he lies about it to the DCI investigators when they show up at the multi-state lottery workplace to interview him. Then he also takes steps to conceal his identity while he's purchasing those tickets. He also doesn't cooperate with the ongoing DCI investigation. And he conceals his connection to Robert Rhodes, who is an important figure in the investigation, working backwards from where the ticket was presented. I just want to start with that to make it clear that if it's just down to raw sufficiency, I think this is an open and shut case for the state.
Can I jump to the statute? Because that intrigues me the most. Do you need both elements, that you have to use reasonable diligence to discover a crime was committed and the person who perpetrated it?
So it's really interesting because there's no specific requirement in the statute of reasonable diligence. Now, and you would ask the question, is this a special criminal discovery rule? And I think that it is, just because it's laid out in the statute, Iowa Code Section 802.5. I know that Wilson says there is this reasonable diligence requirement coupled with the probable cause endpoint to it. And I would agree that it is both offense and offender specific. I think that comes through in the citation of Bumpus.
The discovery rule is a term of art in our legal profession, and it's nothing new, and I think the Wilson case cites some civil cases to borrow from it. And if you're going to have a statute of limitations without a reasonableness in discovering it, you don't have a statute then, because you could sit back for 30 years.
Well, maximum 6 under Iowa Code.
Okay, you could have sat, there's statute of repose in there, they didn't know that, but you could have sat back for the 6 years and not done anything, and then put the tape out. I mean, isn't there some obligation for you to use reasonable diligence? I mean, you knew a crime was committed. I think it's pretty clear that you weren't going to pay it. You knew something happened. And don't you have to use your reasonable diligence to exercise to find the perpetrator? And you waited almost 3 years before you put the tape out.
Well, I think it would be inaccurate to characterize the investigation as just waiting for those 3 years. What the state was really doing was trying to track down Johnson, Shaw, and then that led to Sonfield and Rhodes. There were, as it was put by
3 years?
Agent Anderson said that from that they had to quote him, leads upon leads upon leads, all the while, even though the time to actually get the prize had elapsed, people were still calling in with their claims, asserting that they had purchased the ticket. Even though there was nothing to gain from it, it didn't stop people from doing that. And so keeping the video secret was a very important part of weeding out those claims efficiently. Not to mention, if the video had been disclosed publicly, suddenly those claims become more sophisticated. It's, hey, you look a lot like the guy in this video, call in, and don't forget to tell them that you were wearing a hoodie, you paid with a $50 bill, and you bought 2 hot dogs.
I hear you, but the problem is, isn't that a jury question, whether they act reasonably in a civil trial? It's always a jury question whether or not the discovery rule, unless it's pretty clear cut, but the jury's always instructed whether or not they brought the case within the 3-year, or the 3-year, or the 2-year, or the discovery period. And the first question, at least in the jury trials I've been involved with, where the discovery rule was involved, before you even get to whether or not there's liability or whether or not there's damages, the first question is, did the statute of limitations run? And the jury's instructed what's reasonable. Now, you could argue to me what's reasonable, but isn't that really a jury determination?
I think there's a really good reason why it's not a jury determination in this context, and the reason is because it introduces a whole sideshow into the trial. Suddenly, and this was discussed during the trial, that if the state suddenly needs to prove the reasonableness of its investigation over that period, all of this extra evidence that is about not only what the defendant did and was alleged to do, but also what all of the agents acting on behalf of the state did for that 3-year. And then we're asking the jury
with a bifurcated trial. I mean, I've tried jury cases where the discovery rule, and we had a whole big sideshow. We'd have a 5-day trial, and 2 days we're dealing, or 2.5 days we're dealing with discovery. I mean, that's a viable issue.
I think there's a policy question over whether this is what we'd prefer. And to that end, I think that it's for the legislature to make that decision based on how they write the statute.
I'm looking at Lefebvre on criminal, and he says that it's a question of law, which is what the trial court found. It's for the jury to find whether the conduct occurred within the time period, but it's for the court to decide what is that relevant time period when the statute of limitations ran. And that's the state's position, I take it?
Yeah, and I think that's very reasonable. I would agree with that entirely.
And let me ask you about Section 802.5, since that's what we're interpreting. 802.5 says if it's a fraud offense, and I realize there's a debate whether tampering with lottery equipment is a fraud offense or not, but if it's a fraud offense, then the state can bring the charges within 1 year after discovery of the offense. I take it is the state's position that the offense means tampering. So the fact that the state may have known there was something fishy going on with efforts to redeem this ticket is a different question from whether they knew whether there was tampering with the computer. Is that correct?
That's correct. That whatever you could say about what the state knew before Boardman's tip came in, after Michael Boardman saw the video, identified Eddie Tipton and said, hey, he works for the lottery. Before that, whatever the state knew, we thought that this ticket, we had no idea that this ticket had been purchased illegally or that there had been some kind of fraud in the draw. Once that tip came in, suddenly it's a whole new ballgame for the state that we now have reason to suspect a whole new type of crime, including tampering.
That's still somewhat my question, and it goes to the reasonableness of the discovery of the crime. It's clear that once you disclosed the videotape, it was almost an instantaneous response that somebody could identify this person as being an employee of the multi-state lottery here in Iowa. And I just don't, I guess I want the state's position as to why you wouldn't, something's fishy really pretty early on, and then the best evidence that you have is this videotape of the person who bought the ticket, who is going to be somewhere along this path of dishonesty and deceit if you take the state's position. So why would you wait that length of time to do it, and is that really reasonable? And I know you've started to answer that before, but...
Right, and I think I already touched on the idea that if more plausible claims come in, that makes it not only harder to weed through them, but also harder when we eventually get to trial against the real purchaser.
Plausible claims, I guess I'm struggling with that concept. because anybody can say they put on the coat and that this is them on the audio portion of it, but, you know, they still have to have the ticket and have some explanation as to what happened to the ticket, how it got out of their possession, how, it just seems so
And the explanation
attenuated to me that I'm just still struggling with it.
And the explanation that they would give on how the ticket got out of their possession would take a lot of time and investigation to disprove. I also want to point out that it's very easy to critique this investigation in hindsight. It's the way that this tip came in was not from anybody in Iowa who saw the video. The tip came in from a lottery employee in Maine. It's really a very unexpected thing that not only was this viewed by anybody outside of the state of, or that I suppose it was kind of expected that lottery employees would pass this around, but the idea that one of them would be able to identify this person, the idea that this video would get enough circulation that an immediate identification would come in, I think it's not to impute that knowledge or that sort of foresight to these investigators. I mean, hindsight is 20/20, and I do also want to point out that the state made that decision based on its assessment of the statute of limitations that it thought it had to play by. Based on what the investigators knew, the last date that the claim was really made and advanced, I think, was January 16th or 17th in 2012. When they make the decision to release the video, I mean, they're playing it close to the chest until that point for a reason. Then they get to October 2014 and they have to say, well, we're running out of time. It's time to, you know, pull out all the stops and play our last card and see if we can get this. And to call it, is it the decision that you or I would have made in investigating this? I don't really know. It's really unfair, I think, to call it unreasonable in hindsight based on what we know today compared to what they knew then. I think that the next thing I need to talk about is whether fraud is a material element of this tampering offense. So Wilson depended a lot on Equals, which is a Pennsylvania case. Pennsylvania has a statute just like 802.5. The difference is that Pennsylvania also had, well, in Equals, what the Pennsylvania court said was fraud is a material element of the offense if it's inherent, if it's inherent in the offense and renders discovery more difficult, and based on the connection between the fraud and the harm or evil that is sought to be prevented. I think that's kind of a holistic way to look at whether it's a material element, and I think that's very clearly satisfied here that.
But don't we narrowly construe statute of limitations ordinarily? You're being fairly generous with fraud, it seems to me.
I don't think so. I think that fraud is definitely inherent in this offense. The way that tampering was defined as the unauthorized alteration of the computer system or the computer program. There's no way that you can actually influence the winning of the lottery prize unless that tampering goes undetected. The moment that it's disclosed, it becomes impossible to influence the winning of the prize that way. Now, there's also a more hyper-technical way that Pennsylvania courts apply this, and this has come through in some of their cases that have built upon Equals. Pennsylvania, unlike Iowa, has a statute that defines what material element means, and then separately defines what element means.
It's kind of curious that the statute, as you know, lists fraud as one of the possible bases for liability, and yet the jury instruction omitted that term and just used the other term. And that's a little curious, is it not?
Well, the jury
It
instruction...
used tampering rather than fraud, right?
Actually, the jury instruction did say the state has to prove all these elements of fraud.
Of fraud, and then
Right,
listed
it still labeled it a fraud offense, but it gave the elements focusing on tampering. And I think that that's actually a good way to phrase it because it clarifies to the jury that we're focusing exclusively on tampering as the mechanism for committing the fraud offense. That we're alleging that Mr. Tipton committed fraud by making an unauthorized alteration to this machine with the intent to influence the winning of the Hot Lotto prize. And the only way he could do that was through the concealment of that extremely material fact all the way through to the payment of the prize, and then I guess long after.
I mean, thefts involve concealment too, right? I mean, oftentimes, at least.
Theft by deception.
Usually. Well, not just plain theft. If I want to steal some money from the Quick Trip, I reach my hand and grab the cash and conceal it. So concealing doesn't quite get you there, I don't think.
I think you're correct that concealment can help in the commission of offenses that are not fraud or don't have fraud as a material element. The line I would draw is that the concealment is inherent and absolutely indispensable in the commission of this offense, which I think makes it very different. That without the concealment of the tampering, if he had disclosed, like, by the way, I installed
I
this
don't know of
program.
many public thefts.
Well, there's if you grab it and run away, you can commit the theft, right? But the concealment is not necessarily inherent in the offense. And I think that this lines up very well with the rationale for the fraud extension. And Equals lays it out very well and says, the reason that we have this is for offenses where concealment or fraud in the commission of the offense that's inherent in the offense makes it more difficult to discover and prosecute within the normal statute of limitations. I also want to point out that the Pennsylvania statute defining what an element is says something can be an element if it either is part of the state's necessary proof or if it negatives a defense or a justification.
You said in your statement concealment or fraud, that the Pennsylvania said. Our statute only says fraud.
Well, their statutes are actually identically written to ours. I was just kind of using the statements or the ideas interchangeably. I think that concealment of a material element or a material fact of one's own creation, I think, is classified as fraud, or at least as deception within our statute. And theft as deception qualifies as an offense where the material element of fraud is present. So I think that
This, Counsel, the statute also allows more time to prosecute if there's been a breach of fiduciary duties. What were his job duties, and is the state relying on that in the alternative?
I don't think that the state put forward that alternative justification below. I don't know that we're permitted to do it now. I think it would have been, if we had advanced it, I think it would be applicable here. I'm not sure that we're entitled to do that. But I do think it would be possible to make that argument.
All right, focusing on the fraud element, isn't tampering simply a form of fraud in this context?
Yes, exactly. I think that's how it was charged and how it was treated in the ruling on the motion to dismiss, and then how it was treated throughout the trial in the jury instructions and then submitted to the jury. That this is a fraud offense. It was based on a false representation or a concealment of a material fact to influence winning and take something that Mr. Tipton was not entitled to, and it's inherent in the offense, made discovery more difficult, and the extension applies. Thank you.
Mr. Sloven, thank you as well. Rebuttal argument, Mr. Stowers?
Well, really quickly on this last point about what constitutes a material element of fraud under 802.5. That statute is actually the statute that's commonly adopted by many states across the country. An element, I think we all know, under the criminal law means an element of the offense. And I addressed this point about the Pennsylvania statute on page 16 and 17 of the further review petition, which I think is worth just pointing out to the court if you want to read that later. But element...
Let me ask this question on that. You know, if I roll back my odometer, knowing I'm going to try and sell the car, I mean, right?
Well, it's in some generic sense, it sure is, but it's got to have an element to the proof of the charge, is what the statute's going to.
Yeah, okay. But I think all the elements are arguably there. Although a machine is involved, like rolling back the odometer, and here it's playing with the computers. You make it so the computer spits out a particular number. People think it has been selected randomly, but it hasn't. And so there's a misrepresentation of material fact coming out of this machine. But boy, doesn't that taste a little bit like fraud?
Oh, in a generic sense.
Missing. I mean,
Well, the definition of fraud from Wilson and in all the cases, including the Pennsylvania cases, is there had to be a false representation
I think there is a false
of a
representation.
material matter. This has to be an element of the offense, though.
But
In tampering, no. Tampering means that you altered or changed the functions of the equipment with the intent to influence the winning of the prize. That's what it means. Now, that doesn't require any false representation or anything else. And as we now know from subsequent investigation, that never happened anyway. So I don't know what we're talking about on the tampering count, but I just don't think it applies because it's not an element. There's no material element of fraud in that count whatsoever under any stretch. Now, when you go back and look at that count as well, I think that count separately, when you look at it on the sufficiency of the evidence question, there's absolutely zero evidence that anything about these computers that picked the numbers, or the computer, one of the two, was in any way touched or tampered with in some way to alter or change its functionality for the December 29, 2010 draw, or that it was done on November 20th of 2010, which is the specific thing they had to claim. And, you know, we could talk about all these other issues, but at bottom, we have no evidence of the theory that they alleged, and their theory was that Tipton went into the room, he stuck this little thumb drive into the computer when it was unlocked while other people were standing around him watching, did this all in a 2-minute window that was not clearly videotaped, snuck back out of the room, his 300-pound self, and somehow during that time he had loaded this magic software onto the computer, and that magic software, which was loaded on November 20th, 2010, came to life on December 29th, 2010, altered the ordinary functions of the computer. Presto magico, his numbers come out, and he wins. That's the theory. Now, the problem with the theory is it's great. Hey, it sounds great. They've written movies like this stuff, you know. Problem is you got to have evidence, and there's no evidence that that happened. In fact, the only evidence is that the software that was run on December 29th, 2010 was the very software that had been approved and installed years earlier, and it was working fine. And it was operating fine. And they did all the cross-checks, all the checking. That software was the software that picked those numbers, not some rootkit program software that fooled everybody else into thinking it was the software running. It was the original software that ran that night. And that's what the evidence is. There's no tampering with that original software. There's no alteration to it. That's the software that ran according to the evidence. And
he involved in developing it, your client?
sure, but that's not what he's charged with. He's charged with going into that room on November 20th, 2010, and doing something to alter it.
We've been through this, but again, we have this remarkable coincidence that all these people place him buying the ticket, concealing his identity, making false statements afterwards.
I don't think he concealed his identity. I don't think that's anywhere in the record. I think there's people that identified the clothes he was wearing, his appearance, his manner, his speech, everything else that said that appears to be him, visually somewhat similar and audibly similar, and I think I'm out of time.
Well, wasn't there evidence that he was in the room and he did have access to the device? And he was in the room. An opportunity to
right. He was in the room, and when he was at the computer, there's an actual snapshot in an exhibit of the time clock open on the computer, because the time clocks on these computers have to be changed periodically because they're not connected to the internet. So the staff that worked there would request somebody to come in and do that. And he was at the computer, and all of the indications are, and the testimony is, that everything that they see and everything logged and everything that occurred was consistent with a clock change, a time change.
Didn't the witnesses say they weren't paying attention to what he was doing?
Well, look, nobody's saying that it's not theoretically possible
Well, then we're
that
talking about
something could have
circumstantial
happened.
evidence, aren't we?
Well, we have to have some evidence. I think it's got to be more than circumstantial. What we're talking about in this case is like these arson cases. You went to the gas station, Judge, a month ago. You apparently filled your gas can up with some gas. You know how to use matches. And guess what? Yesterday your house burned down. And you got insurance on your house. So you got motive, you got opportunity, you got knowledge. They don't know how the fire started, but the house burned down. And now you're charged with arson, and that's their evidence. Are you guilty of arson based on that? And that's really what the state's case was here. And it's not sufficient under the cases of this court. I see my time's up. I thank you for your time. And appreciate your work. Thank you.
Thank you as well, Counsel. The case of State of Iowa versus Eddie Raymond Tipton is now then submitted to the court. And before the bailiff adjourns, let me just make a few comments to those who are with us this evening. We want to thank you very much for taking part of your evening and spending it with us. It is essential to good government that the public be informed of the way that its government works, and we all commend you for your interest and your attention this evening. All of us in this room, each one of us care deeply about justice, and our Iowa courts work hard to secure justice to everyone who enters into our courtroom. But we not only do it in the decisions that we make, but we secure justice in the process that we provide for people that do come in to our system, and for the process that we engage in doing our work. So we hope that this has been visible to you tonight as well. We will make a decision in this case. It'll be through a written opinion. It'll fully explain the rule of law that is applied to reach the result, and you would expect it, or you should expect it, within about 90 days. And you can follow along on our website that will alert you as to when that decision will be made. We also look forward to joining you in a reception on the second floor of this building in the Light Court. So again, thank you very much for being here. I'll ask the bailiff to adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.